Ready, start. They could take direct action against the debtors by taking possession of secured assets and selling them. They could also take over the management of the business of the borrower. Therefore, they could also appoint any person to manage the secured assets, possession of which has been taken over by them, and could require at any time by notice in writing to any person who has acquired any of the secured assets from the borrower and from whom any money is due or may become due from the borrower to pay the secured creditors so much of the money as is sufficient to pay the secured debt. In order to further the objects of the securitization and reconstruction of financial assets and enforcement of Security Interest Act 2002, the Act contains a non-obstante clause in Section 35 and also contains various acts in Section 37 which are to be in addition to and not in derogation of the securitization and reconstruction of financial assets and enforcement of Security Interest Act 2002. Three of these acts, namely the Companies Act 1956, the Securities Contracts Regulation Act 1956, and the Securities and Exchange Board of India Act 1992, relate to securities generally, whereas the Recovery of Debts Due to Banks and Financial Institutions Act 1993 relates to recovery of debts due to banks and financial institutions. Significantly, under Section 41 of this Act, three acts are by the schedule to this Act amended. We are concerned with the third of such acts, namely the Sikh Industrial Companies Special Provisions Act 1985 in Section 15 1, of which two provisos have been added. It is the correct interpretation of the second of these provisos on which the fate of these appeals ultimately hangs. This is what then brings us to the doctrine of harmonious construction, which is one of the paramount doctrines that is applied in interpreting all statutes. Since neither Section 35 nor Section 37 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002 is subject to the other, we think it is necessary to interpret the expression double inverted comma or any other law for the time being in force double inverted comma clause in Section 37. If a literal meaning is given to the said expression, Section 35 will become completely odious, as all other laws will then be in addition to and not in derogation of the securitization and reconstruction of financial assets and enforcement of Security Interest Act 2002. Obviously, this could not have been the parliamentary intendment after providing in Section 35 that the securitization and reconstruction of financial assets and enforcement of Security Interest Act 2002 will prevail over all other laws that are inconsistent therewith. A middle ground has necessarily to be taken. According to us, the two apparently conflicting sections can best be harmonized by giving meaning to both. This can only be done by limiting the scope of the expression double inverted comma or any other law for the time being enforce double inverted comma clause contained in section 37